Hello, good morning, and welcome to today's episode of Modesty's Money Masterclass, episode number 35. Okay, today is Monday, the 29th of June, 2020. So June is almost gone. So we are close to seeing this year halfway through. Um, still can't imagine how fast and how quickly this year has gone, and the COVID-19 has not helped matters either. But anyway, we're not here to talk about COVID-19 or how quickly the year has gone. We're here to do our business. Every Monday we come here and we learn about money and the things that help us improve our relationship with money. So today we're going to be continuing on the series we've been dealing with for the past couple of weeks, which is understanding and improving your credit score. And this is part 3 of that. And today we're going to be continuing from where we stopped last week. Last week we talked about how your different accounts are reported on your credit report or your credit profile. So today we're going to be talking about something different as well that appears on your credit profile. And we're going to be talking about adverse events, how they are reported on your credit profile, what they mean, and how they impact your credit profile. All right, so for those of you who are in jurisdictions or regions where credit reports and credit profiles are not a thing, you may find this true, but at the same time, trust me, there are a few things you could pick up from this session that could help you generally in managing your finances, apart from trying to maintain a good credit report. But first of all, how has your week been? And how was your weekend? I hope you all had a good weekend. Even if it wasn't all that good, hey, shake it off. This is a new week, a brand new opportunity for you to make a fresh start. And I encourage you to make the most of it. Okay? As for me, I've had a very good weekend. I had a very good week last week, though it's been very busy as well. But then I'd rather be busy than being idle, doing nothing. All right, and I want to be busy doing things that are productive, and I have been busy doing productive stuff all through last week. The weather this week has been a little bit of off and on. 2 days hot, 2 days lukewarm, really not cold, but at least we like it milder. So you cannot be in the UK and not talk about the weather, really. So we're allowed to talk about the weather for as long as we want. Anyone in the UK is a good weather forecaster, so we are all interested in the weather every single day. So I hope you've had a very good weekend, and then please make the most of this week. So today we're going to be talking about adverse events on your credit reports. Now these are records that are on your credit report that affect your credit rating negatively, and they either prevent or limit your access to credits and other things that you might ordinarily have access to. Or even if you manage to have access to them, you will not be treated as equally as those whose credit reports have got no adverse events. All right, so adverse events on your credit report means you are a high risk to the lender, you are a high risk to the creditor, you are a high risk to the people you want to deal with. So they are advised to deal with you cautiously. If at all they're going to deal with you, you will have to pay a premium for that. That premium might come in the form of high interest rates for the loans you're getting, or low credit limits if it's a credit card you're going to be getting. So basically, they are going to be treating you like someone who cannot satisfactorily conduct himself financially, and satisfactorily fulfill their financial obligations as a result of one or two of those adverse events on your credit report. Now, some of the adverse events on your credit report that we're going to be touching on today will be things like bankruptcies, CCJs, IVAs, defaults, missed payments. Now, these are some of the things that appear on your credit report, and they appear as adverse events, and they are the things that are limiting or preventing you from having access to credit reports. And interestingly, adverse events in some cases don't just affect your access to credit. They sometimes also affect the level of employment opportunities that you're able to get. Trust me, there are some employers in this country who base their decision on your credit report, how bad it is or how good it is. And you can imagine if you were qualified academically by way of qualification and academic qualification, and then the only thing that stopped you from getting that job is the adverse events on your credit report. That must be disheartening, isn't it? Especially for those of us in the financial services sector. The financial services, some areas of the financial services, especially the regulated side of things, they pay some good attention to things on your credit report, which is why we have to pay a lot of attention to what happens around our credit profiles and try and guard them as jealously as we can. There are some other professions where they also look at your credit report and just to make sure that you are who they want you to be. If they need to know whether you've got criminal records, they need to know whether you've got bankruptcies, they look at your credit report. So let's look at bankruptcy first of all. Funny enough, last week during our mortgage masterclass, we discussed bankruptcy. Yeah, we discussed bankruptcy as a type of borrower, somebody who is bankrupt, how they are treated by mortgage lenders. And to be honest with you, this week and today, it's not going to be different or that different from what we spoke about during our session in the mortgage masterclass last week. But then I understand that the audience for money masterclass may not be the same audience for mortgage masterclass. So I may be repeating most of the things that I said during the mortgage masterclass on bankruptcies as it relates to your credit score. The idea is for you to understand what bankruptcy is all about and how bankruptcy is reported on your credit reports and how it affects your credit rating. Okay, so we did say last week that bankruptcy has a route to insolvency, and we did define an insolvent person as someone whose liabilities exceed their assets. When what you owe exceeds what you own, it means you are insolvent, you are illiquid, you cannot meet your financial obligation. That's number one definition of an insolvent. Second definition is when you cannot meet your financial obligations within a reasonable time of those financial obligations falling due. Okay, that is the second definition of an insolvent. So when these two situations occur in someone's financial life, that person is declared insolvent. Now, you can be insolvent without being bankrupt. You are only bankrupt when the courts, the county court in case of the UK, declares you or pronounces you bankrupt. So there has to be a bankruptcy order that was brought before the court, requiring the court to declare you bankrupt. That bankruptcy order could have been brought by either yourself or your creditors, the people you are owing. They can approach the court and say, look, this guy has not been able to pay what he owes within a reasonable time of them falling due, and we have done everything possible to see if he can pay, and it's obvious that he cannot pay. So please, court, declare him bankrupt. Right? Your creditors can do that. Now, you can even declare yourself bankrupt if you look at yourself and you feel like, well, all these debts that I'm swimming in, there is no way I can come out of it. I have no way of paying them. I haven't got any money to pay them. I'm just going to go bankrupt and then let the system deal with it. So you can actually approach the court on your own and decide to declare yourself bankrupt. So you are only bankrupt when the court pronounces you bankrupt or when the court declares you bankrupt. But that has to be preceded by a bankruptcy order filed by either yourself or by your creditors. So you or your creditors can file a bankruptcy order. Now, we said last week as well that a bankruptcy order cannot be filed for a debt that is less than £5,000. So you must be owing this creditor, this company or this individual, at least £5,000 for them to be able to bring to the court an order to declare you bankrupt. So when you are declared bankrupt, what happens is that your case is transferred to somebody we call a trustee in bankruptcy. Now, this trustee in bankruptcy will now take control of your assets. They will take control of everything that you've got, and then they will liquidate your assets. That includes your property if you've got any property. So every asset you've got is up in the air the moment you're declared bankrupt. But then there are exceptions to that. Exceptions are assets that are very important for your means of livelihood, and assets that are very important for your daily living costs. Those assets can be considered, and they will not be included in the assets that will be liquidated by the trustee in bankruptcy, to pay off your creditors. Now, if, for example, you have a laptop, and that laptop is the laptop you use to work, and your earnings, your income, your daily living depends on that work, you can be allowed to keep the laptop, so the trustee in bankruptcy will not sell the laptop, okay? Or if you are driving, and it's very, very critical that you keep that car so that you can get to and fro work and be able to earn a living, yeah? You might be allowed to keep the car because it's very, very essential to your work and to your living. Okay, so there are exceptions like this exist whenever there is a trustee in bankruptcy in operation. All right, so you are allowed to keep some of those assets to enable you at least still function normally or near normal as much as possible. But then everything else is up in the air. Now, when those assets are sold or liquidated, the trustee in bankruptcy will first of all pay the court fines. The courts, the judges will first of all, the system, the government will take their court first before then they start paying your creditors. And then they will try to pay as much creditors as possible with whatever you have that has been sold or liquidated. Obviously, there are certain debts that are prioritized, above others. If you have a property, for example, and that property is sold, if there is a first charge on that property, the creditors, the bank or the institution that loaned you that money have a first charge on property, so they will be paid first. So there are other categorizations of creditors, and how much each person gets then is determined by the trustee in the bankruptcy. So in most cases, the bankruptcy order lasts for 12 months. Okay, and after 12 months, you are declared what we call a discharged bankrupt. Okay, so for 12 months, you remain in that bankruptcy period, and after 12 months, you are declared a discharged bankrupt. But the bankruptcy still remains on your credit report. It will show the dates you were made bankrupt. It will show the dates you were discharged from bankruptcy. But then it remains on your credit report for 6 years, just like every other adverse event on your credit report. So even though you've been discharged bankrupt, but the record is still there. So whenever any lender makes a search on your credit profile, they will always see that you've been made bankrupt before, or you are just freshly discharged from bankruptcy, or you are still bankrupt anytime you try to borrow money. Now you might be wondering, why would a bankrupt person want to go and borrow more money when you haven't even finished paying what you're owing? Well, you might be surprised to know that even though the law doesn't always prevent you from borrowing if you are bankrupt, you are simply not allowed to acquire an interest in property that's in the land. So when it comes to property purchase, you are simply not allowed to even acquire an interest in that. But other borrowings, like credit cards, loans, and stuff like that, store cards, yes, you can apply for them even while you are still made bankrupt. It's simply a case of there are things to consider. The debts, are they more than the borrowing you are looking to get into, is it more than £500 or less than £500? As long as it's not a mortgage, if it's less than £500, yeah, an undischarged bankrupt can borrow that amount as long as it's not a mortgage. So if, for example, credit card of say £250, an undischarged bankrupt can actually go ahead and take out on that credit card as long as it's less than £500. So it's up to the lender to decide whether they want to take that risk or not. But if the borrowing is more than £500 and it's not a mortgage, so you can legally an undischarged bankrupt can legally borrow more than £500, which is not a mortgage, but they must disclose to the lender that they are undischarged bankrupts. You owe it a duty to the lender to disclose to them that you are undischarged bankrupt. Okay? But if it's under £500, you are not obliged to declare that, whether you are undischarged bankrupt or not. But the lender will find out anyway. They will see it on your credit report if they carry out a credit search, unless they don't carry out a credit search, or maybe it's a loan that is secured on something and they don't need a credit search to know whether you are credit worthy or not. Okay, but it's on your credit report. But if it's above £500, you are required to declare to the lender that you are undischarged bankrupt. And talking about disclosure, we spoke about disclosure of bankruptcy last week as well. So once you are discharged from bankruptcy, you are entitled to borrowing, really, even getting a mortgage. But then you must declare a previous bankruptcy. No matter how long ago it's been, even if you've been made bankrupt over 6 years ago and it's no longer showing on your credit report, if the lender asks that question on the application form, you are bound to provide that information. If you do not provide that information, it could amount to you being declared culpable of fraud. It could lead to you being accused of fraud. So basically, you still have to declare that you've been once made bankrupt if the lender decides to ask that question as they want to know. So there is that obligation of disclosure on your own side. Okay, so some lenders will then make up their mind whether they want to lend to you or whether they want to consider how long ago it was that you were made bankrupt. So some lenders who want to lend to you might say, okay, if you've been discharged, if you've been a discharged bankrupt person in the last 3 years, and in that last 3 years you have managed your finances very well, we are good. We're okay to lend you. Okay, they can decide to deal with you on that. Some might require you to be discharged from bankruptcy for at least 6 years before they deal with you. Some might even are happy to deal with you the moment, a day after the 12 months you were discharged. They'll say, okay, you've been discharged from as a bankrupt, we're happy to deal with you. Different lenders have different criteria, but those criteria come at a price. Now, if they decide to deal with, if that record is still on your credit profile within the 6 years, and the lenders can still see it, they will offer you products that are suitable for people who have adverse credits to enable you build your credit profile. But some lenders, because the records on your credit report are there for 6 years, if it's not shown on your credit report, they are not interested. All right, they are not interested. Hi, Patrick. Good afternoon. Thanks for coming on. If they're not if it's not on your credit report, they are not interested, so they will just waive that and move on. So it depends on the lender's disposition, really, and how much importance they want to attach to how long ago you've been discharged bankrupt. Well, for high street banks and high street lenders and institutions, it's a no-no. As long as it's showing on your credit report, no way. There is no way they are going to be dealing with you. So there are specialist lenders for credit cards, for loans, for mortgages and all that, who deal with people who have been discharged bankrupt, even if it's still showing on their credit reports. So those credit products that are available for people like that are usually referred to as credit builder products. so that when you get that credit, it gives you an opportunity to start afresh. Then you start afresh, and then you start managing your credit, and then for every payment you make, for every time you manage your credit significantly well, it shows on your credit report, and then it start building your credit report again and building your credit profile again. Okay, so that's bankruptcy. Now, when bankruptcy appears on your credit profile, these are the effects that it has on your credit, on you, and the way that lenders view you as a customer, as a potential risk. So the risk assessment is based on what is on your credit report as far as bankruptcy is concerned. It lasts for 12 months, and after 12 months you are discharged, but then it still remains on your credit report, and lenders make decisions based on that. Okay, the other adverse event I would like to talk about today are county court judgments. They are called CCJs. You know, I've had clients that speak to me, and I ask them on the phone, over the phone, have you got a CCJ? And they're like, what's that? I said, okay, so don't worry. If you don't know what it is, it means you haven't got it. Okay, so you haven't got it if you don't know what it means. It's county court judgments. So if you haven't got it, if you haven't heard of it, if you don't know what it is, then it's you haven't got it. But then it's important for you to learn what it is, so that you know how to avoid it, and you know how it impacts your credit profile. So these are judgments and pronouncements that are made against you by county courts. Now in England, in the UK, county courts usually take care of small cases and small claims. They are also called family courts. They deal with family disputes. They deal with marital disputes. They deal with small claims for people who are owing people money, whether it's an individual or an organization. If there is a debt or trade dispute that you guys have not been able to settle between or among yourselves, you can bring it to the county court, and the county court will make a pronouncement or judgment. So these county courts, they specialize in settling small claims and small disputes. Now, things like unpaid debts could be brought before the county courts, and then the county court will take a judgment on that based on the evidence that has been placed before them. Now, for a lot of creditors, this appears to be like the last resort for them. If they have made every effort to get you to speak to them about these debts, and you have not done that, and they feel that they have no other option, or they have approached you and there is a disagreement between you that is basically irreconcilable. And if that difference and disagreement is irreconcilable, the both of you might decide, okay, we'll take it to the court to decide. So the small courts, like county courts, are the ones that pass this kind of judgments. So creditors would have no other choice than to go to the courts and say to the court, this guy is owing us and he's refused to pay us that money. So creditors could be anybody. It could be your landlord. Maybe you lived in somebody's house and you did not pay rent, and the landlord has been trying to get you to pay the rent and you have refused to pay the rent. And maybe you might even owe the rent and move out of that property. The landlord still have a right to chase you for the rental arrears, and if you still refuse to pay, they take you to the county courts, and if you receive a county court judgment against you, it's called a CCJ. Right? It's called a county court judgment. The moment that judgment is pronounced and the judge says, yes, he is guilty, that thing goes onto your credit profile, right? It's registered against you, and it becomes an adverse effect, and it's, dramatically, significantly affects your credit profile or your credit rating. Again, CCJs will remain on your credit profile for 6 years. And they could prove costly for you, not just in terms of your ability to get loans or credits, but employment, like I mentioned earlier on. For example, if you've got a CCJ for debts, and there could be as many CCJs on your report as possible. So as it doesn't, there is no maximum number of CCJs that can. Any company you're owing that feels like they want to take you to the court, they can take you to the courts. And then once that judgment is passed, it's registered against you. Once judgment is passed, it's registered against you. So a lot of the times when you're making credit applications and you ask, have you had any CCJs? It's important for you to check your credit report and see whether anything has been registered against you. Some people have had CCJs and they didn't even know because they moved out of a particular property and letters have been going to that property and they didn't even know that their creditors have been writing them since they moved out of that property. And then all of a sudden, they go to make credit applications and it's declined and they're like, what happened? They pick up their credit report and, hey, there's a CCJ on my account. They don't even know when that CCJ was put on their account or was registered against them. Which is why I mentioned last week, it's very important that when you move home, please try and redirect your mails, okay, through the Royal Mail mail redirection facility. Redirect your mails so that when those mails come to your previous address, the Royal Mail will redirect them to your current address. That way, you make sure you keep on top of correspondences between yourself and your creditors and whoever wants to get in touch with you, and you avoid, getting CCJs registered against you simply because you've moved home. Okay, that's one way people get CCJs and they don't even know. In fact, I had a client whose property I was going to manage for that client, and the client came to me and said, hey, I just checked my credit report and there's a CCJ on my credit report. And I was like, how? Who registered against you? I said, oh, it was the previous agent. They did this boiler thing for me in my house, and there's been a dispute between me and them, and they said I was going to pay for it, and I was telling them that they were still owing me. They are supposed to pay for that boiler out of the debts they are owing me, and we disagreed on that, and they've kept on that, and I didn't know they would make good their threats of going to court. And they went to court because she didn't have the privilege of responding to that letter, because the letter came to an address that she was not even living at, and she was no longer living at. So she didn't even know, and all of a sudden there's a CCJ. So these things could be very, very, messy at times. Okay, so, and now she's in the legal process of trying to set aside that judgment. So setting aside the judgment on CCJ will, will enable the courts to look at your case and decide whether you have enough case to set aside the CCJ. Another way you can deal with your CCJ is, for example, if you have a CCJ and you receive the court letter saying that this judgment has been passed against you, you've been found guilty, you are owing this person £500 plus court fees. You are meant to pay this money as soon as possible. Now, if you pay that money within 1 month of you receiving that letter, and if you pay the whole of that money within 1 month of you receiving that letter, that CCJ will not go on your credit profile. Okay? If you pay the whole of it within 1 month of that judgment being registered against you, the CCJ, the judgment will not go on your credit profile. But if you haven't got the money, and then you enter into an agreement with the creditor and say, okay, I haven't got £500 now, but I'm happy to be paying £20 every month to clear this within the next 2 years, or whatever agreement you have. If you reach that agreement and the creditor is okay with that, the CCJ remains on your credit report even after you have paid that money. It will still be there for 6 years. But if you finish paying that money in installments according to the agreement, what you can do now is you can write to the court and say, I have finished paying this money according to my agreement with this person. Can I get a certificate of satisfaction? The court will issue you a certificate of satisfaction, and then they will update the credit reference agencies about that situation or the status of that CCJ. So the credit reference agencies will now update your profile to say that you have satisfied this CCJ. So it will show satisfied on your credit report. Even though it will remain there, but at least it will show satisfied. So any creditor and any lender or anybody who's looking at your credit profile can look at it and say, okay, yes, he had CCJ, but he satisfactorily conducted himself and he has satisfied that CCJ. So it means, he's good again. Okay, so it changes the outlook on your credit. Yes, you've got the CCJ, but you've been able to manage it. But the key thing is not actually managing that CCJ. The key thing and the most important thing is how to prevent the CCJ from occurring in the first place. Okay? Always seek out-of-court settlements with anybody or any creditor. If you guys can reach an out-of-court settlement, reach for an out-of-court settlement and make sure it doesn't even get to that point. But if you're still at that level of irreconcilable difference on agreement, if you're confident enough to let that case go to to the courts to decide, two things you've got to be very sure is, first of all, make sure you have a very strong case, right, that will warrant you will not be found guilty after all that. Secondly, make sure you have a plan B to say, if I'm found guilty after all this and I'm asked to pay this money, I will make sure I have the whole of that money in my account in readiness to pay these debts, so that this debt will not go on my credit profile excuse me, as a CCJ. It's very, very important that you're very aware of these two situations. Make sure you have a strong case to warrant that you can defend yourself and that you will not be found guilty. Secondly, make sure you have a plan B for when you are found guilty, that you have enough money to pay for that debt within 1 month of that debt falling due, to stop it from even appearing on your credit report in the first place. So it's important that when you update your when you get that update from the court and you write the courts, that the courts give you a certificate of satisfaction, and then you make sure that your credit profile is updated accordingly to show that you have satisfied that CCJ. Now, when you have CCJs, I talked about the impact it could have on employment opportunities. When employers who are interested in your credit profile, when they look at your credit profile and they see you've had CCJ, they look at how many CCJs you've got. If you've got that many CCJs, and those many CCJs have been following each other subsequently, it kind of paints a picture of someone who is careless, really. Because if it's just say one or two, you might say, okay, it was a mistake, or there is one which it was a utility thing, maybe your gas supplier or your mobile phone provider, and things happened and they went to, it's a small amount, maybe 100, 200, 300 pounds, or even less than 500 pounds. Yeah. But then when you have that many CCJs and the employer looks at your credit profile, they are seeing someone who is irresponsible, someone who is not very proactive in managing crises, in managing disagreements, in managing credit commitments. Because if you were that proactive, if you were that careful about your image and who you are, you wouldn't allow that many CCJs to be on your credit profile in the first place. Okay? Now, the other way an employer can look at this is, an employer can, if you're in the financial services industry and you've got CCJs of debts from credit cards running into tens of thousands of pounds, and then you want to come and work for this financial services industry where you're going to be talking to clients and you're going to be managing clients' finances and advising them and making product recommendations. Now, the worry is that this guy is highly in debt. If we employ him and he's going to be making product recommendations for clients, how can we be confident that he's making the right recommendations to those clients and not recommendations that are satisfying him financially the more? For example, if there are, product providers that pay higher commission. The thought of your employer would be that you would be tempted, or you might be tempted. Hi, Emmanuel, Akiyemi, good afternoon. Thanks for coming on. You might be, their worry will be that you might be tempted to recommend to someone product that pay higher commission because you are highly in debt and you would like to pay off your debt as quickly as possible. So that could actually affect your employment opportunities. It could cost you an employment opportunity based on that. And then the CCJ as well, they will also want to know what is it all about. Because you could get CCJ for, marital issues, maybe domestic violence, which will also even give you a criminal record as well. Somebody can go to court and obtain county court judgments against you, barring you from coming anywhere close to them because you are a threat, because you are violent, because you are an abuser and all that. You can get a county court judgment, we have mentioned, for unpaid debts. Utilities, that's a very common one where people pick up useless CCJs on utilities. Even parking charges, right? You park your car and then the parking attendant at the car park management company keeps writing you, threatening you with legal action, and then all of a sudden they make good of that legal action. They actually go to court, and by the time they get to court, that parking charge of £70 would have now become a debt of over £300, because for every letter, every time they keep writing, every time you keep delaying the payment, the amount keeps increasing. By the time it gets to court, it's become a debt of £300, and then it's now big enough for them to say to the court, you are owing this much. And then they will now slam court fees on top of that as well, and that will be your total debt. If the county court finds you guilty of that and they pronounce a judgment against you, it's registered against you. Car parking charges, utilities, credit cards, loans, overdrafts, all these unpaid debts. If the creditors, or if the people, the individuals, even individuals, yes, I mentioned landlords. Apart from landlords, people that you have done business with, right? If you're owing them, or even somebody that's an employee that you refuse to pay, can take you to the county court, right? And then, make a claim against you for unpaid wages. So actually, any money you are owing anybody, that person can actually take that claim to the county. I think the maximum claim you can make to the county court is for any claim about £10,000, and if it's above £10,000, it becomes a higher level claim or a higher level case. But small claims courts can handle claims of up to £10,000. So individuals that you are owing, as long as they have enough evidence to show that you're owing them, whether it's business or personal debts, they can go to the county courts and seek a judgment against you. And if they secure that judgment against you, it goes onto your credit report and it's registered against you. So, like I said, the best way to deal with this is to talk, okay? Talk to the individual, talk to the company, seek resolution, okay? Seek a peaceful out-of-court resolution of that. If you receive a letter or a phone call or a text message from this company saying you're owing us this much, you need to pay this money now, pick up your phone, speak to the company. Am I owing you this much? How? Can you justify that I'm owing you this much? If you are sure that's what you're owing, pay it. If you can pay it. If you cannot, enter into a payment arrangement with them. Okay? And just do everything you can to make sure it doesn't get to the county court judgment stage. Otherwise, if it gets there, remember the two things I said. Make sure you have a strong case and make sure you have a plan B to pay off that debt within 1 month if you do not want it to be on your credit profile. All right, folks, this is as far as we can go today in discussing the adverse credit events on your credit report. And next week, I'm going to round up the adverse events. What I'll be talking about, IVAs and default payments and missed payments and other things that adversely affect your credit report. I hope this has been useful to you. I hope this has been educational enough for you. Please, please, we always say, leave us feedbacks and let us know what you think about what you've heard and what you've watched, and on whatever platform you're watching this, please leave us your feedback. We are very keen to know how this has been useful to you. If you even if it's just to give us a like, a thumbs up, a comments, share this video if you think somebody else could benefit from it, or go to my YouTube channel and subscribe to our YouTube channel. Just search my name on YouTube, Ikenna Omezudike, and there are loads and loads of contents on my YouTube channel that you can watch. In fact, I'm feeling a little bit guilty because one of my clients that I referred to my YouTube channel called me last week and he said, Ikenna, I now sleep on your YouTube channel. I've been watching the backlogs of all the things and all the contents there. I felt very proud and very delighted that somebody found it, worthy of spending their time on watching and listening and learning what we've loaded on our YouTube channel. But please, before you sleep on my YouTube channel, make sure you have your pillow and your duvet. Yeah, you're gonna feel very comfortable. Anyway, thank you very much, and do have a wonderful day and have a blessed week. And I'll see you again on Wednesday when we talk about mortgages on Wednesday. Okay, and then on Monday next week again, I'm gonna talk to you again about money and our money masterclass. Thank you very much. God bless and take care. Goodbye. Stay safe.